So the Jamaican government just lost a big environmental court case, and here's why it matters to you. There's a stretch of mountain on Jamaica's north coast, tucked between the towns of Rio Bueno and Discovery Bay. Locals call it the Dry Harbor Mountain. Scientists call it one of the most ecologically significant places in the Caribbean. And for the last 5 years, it has been at the center of a brutal fight over mining, ministerial power, and who really gets to decide what happens to your environment.
There are those who would want to shape the government in a narrative that it does not seek to protect the environmental assets of the people. I rubbish that narrative.
Last week, a Jamaican court delivered a landmark ruling. The government lost, and the implication stretches way beyond one mountain. A company called Bengal Development Limited wanted to mine the bauxite, limestone, peat, and sand in the Dry Harbor Mountains. This is an ecologically sensitive landmark. It is a rare karst landscape, massive underground water system, and wildlife and plant life found almost nowhere else on Earth.
They filter water, they protect flooding, prevent flooding, they give us protection from storms, as well as being habitat for plants and animals. So they're very important to us, and we've lost a lot of them already.
Jamaica's environmental regulators, the National Resource Conservation Authority, the NRCA, reviewed the application and said no, too risky, too much potential harm. But then, in October 2020, Prime Minister ANJU Holness, acting in his capacity as the minister responsible for NRCA, stepped in and overturned the decision. He approved the permit anyways.
I want to assure the public that the decision was not taken lightly.
8 local residents sued, and 5 years later, they won. So what did the court actually decide? The 3-judge Constitutional Court ruled that the permit was unconstitutional, void, and of no effect. The court found that the mining was likely to breach residents' constitutional rights, their rights to a healthy environment, and to the protection of their ecological heritage. But here's the part that really matters. The court didn't just say the environment was important, it drew a clear line around how much power a minister has to overturn an independent regulator. The judge acknowledged that a minister is allowed to disagree with a regulator. That's not the issue. But this is the key point. If you're going to overrule an expert body, you need to show your work. You need a clear, reasoned, evidence-based justification, and you need to explain it publicly. In this case, there was no such documents, no written reason. The Prime Minister simply said yes, where the NRCA said no. Nobody was told why. The ruling lands right in the middle of a much more bigger political fight happening here in Jamaica right now. The government has pushed a bill called the National Reconstruction and Resilience Authority Act, designed to fast-track reconstruction after Hurricane Melissa devastated the island.
NARA will have special powers to accelerate development approvals as well as procurement, enabling the execution of resilient infrastructure projects at a scale and speed this country has never seen before.
But critics, civil society groups, the opposition, legal scholars have raised alarm because the bill would give the Prime Minister sweeping power to override regulatory bodies with limited to no accountability. And guess what, people? The Senate just passed it.
The Senate has approved the controversial National Reconstruction and Resilience Authority NARA bill, with the government using its majority to reject opposition amendments targeting additional oversight.
And now you have a constitutional court saying, in no uncertain terms, ministerial powers has limits. Regulatory bodies exist for a reason, and when a minister overrules them, they must explain themselves to the public. King Counsel Michael Hilton, who led the legal challenge, puts it plainly. You're entitled to come to another view, but you need a good reason, a demonstrably better reason than the body you're overruling. So what happens next? Well, the government is saying that they're going to appeal it.
It is my understanding that the Attorney General's chambers, they will be appealing. That's my understanding. In terms of timeline on that, I can find that out and get that back to you. In terms of the implications of it, we've not been able to go through, I know I personally have not gone through the full judgment, and that's not been brought to Cabinet for us to look at what are the implications coming from it. But what I do understand is that from my discussions with the Attorney General is that the ruling will be appealed.
So the fight isn't quite over just yet. But the Bengal ruling has already done something significant. It puts the question squarely on the table. In a democracy, who actually gets to decide what's too dangerous to do to your land, your water, and your air? So whose side are you on, people? The regulator who studies the science, or a minister with a pen with no paper trail? I would love to know what your thoughts are in the comment section down below. Thanks again for watching. I am Kemar, and until next time, walk good, everybody.